Hello, everyone, and welcome to the ELR Monthly webinar. Today's topic is SEC's Climate Change Disclosure Rule, and I'll be your guide for the next 30 minutes or so. I'm Kevin Ewing, a partner at Bracewell, a resident in the Washington, D.C. office. The rule has lots to recommend it for your reading pleasure. It's 800 pages or so in its original incarnation with the preamble. We will unpack what is most important about it, but in doing so, just remember that we're not providing specific legal advice right now to solve any of your particular issues. If you have particular issues, feel free to reach out to us. The overview for today is intended to give you a working knowledge of the rule and really what is most important about the issues that you'll need to deal with as in-house counsel and think about. So we're going to talk about the rule's status. Yes, it's been stayed, but what does that really mean? And what are the consequences? Do we still need to comply with it? What should we be doing there? We'll cover the accounting and disclosure requirements that the rule creates, and we'll begin to talk about some of the specific practical implications that are difficult to deal with. What is materiality? What is climate-related risk? And what is the combination? What is material climate-related risk? What does that mean? How do we handle that internally at a company? What are the implications of the rule for all the sustainability reporting that we're already doing on the side that's kind of on a voluntary basis? Should that be discontinued, aligned? How do we handle that? We'll talk about some compliance challenges and some legal risks and some mitigation strategies that we think are useful to think about. So let's dive right in to the rule's status. First, let's note the SEC did ultimately beat the CRA being the Congressional Review Act, which is relevant for all major rules, not just this one. And it set a clock that meant if you didn't meet the deadline on the political calendar, so to speak, there might have been an opportunity for a new administration, if the administration should change, to claw this rule back. But the bottom line there is the SEC beat that clock, and the claw back under the CRA is really not a likely outcome here. But the SEC has stayed its own rule, meaning it has stayed the effectiveness. It has not withdrawn the rule. The rule is still out there. They want to defend it in court, and they intend to defend it in the Eighth Circuit. Why the Eighth Circuit? 6 different circuit courts entertained lawsuits that were filed almost immediately, mainly by businesses and business organizations, and 26 states. So that's more than half the union, really remarkable. But also by NRDC and Sierra Club, challenging that the rule didn't go far enough. All of those multiple suits were ultimately consolidated through the multi-district litigation process into one court, the Eighth Circuit, and that's where all of these challenges will be resolved. The stay of the SEC or by the SEC of the rule does not moot the pending challenges. In fact, the stay is conditioned on the completion of the Eighth Circuit's review. In addition, we should point out that the court itself is considering its own judicial stay. And you might ask, well, if the rule's already stayed, why do you need a judicial stay? And the answer to that is the SEC's stay is from the SEC, and the SEC can unstick its stay whenever it next wants to meet and take a vote on it. So in that sense, that administrative stay or agency stay is unreliable from a litigation standpoint. A court stay would be much more reliable. But there's a second tactical reason to issue a stay, or in considering such a stay from the court. The court will be considering the 4-factor test, at least would likely be considering something like the 4-factor test for an injunction. Among those factors, the likelihood of success on the merits. And so it might afford the litigants an early insight into how the court is seeing the validity on the merits of the rule. Now, there's a lot of tea leaf reading that's going on about what's going to happen in the Eighth Circuit and how the case will be brought forward and when it will be done. Yes, it has been noted that the court is largely consisting of Republican appointees, and indeed only one Democratic appointee. I think more instructive than that, because judges are to be impartial, is the fact that this court has had experience in the case of Nebraska versus Biden, looking at the question whether or not this administration has exceeded its statutory authority. And that's going to be a big part of the challenge here on the SEC rule. And in the Eighth Circuit's case in Nebraska versus Biden, they found that the loan forgiveness, this is the college loan forgiveness program that President Biden put in place a couple of years ago, was in fact ultra vires. And so they stated, and that went up to the Supreme Court, and the Supreme Court agreed. finding that it was an unlawful exercise under the major questions doctrine. So we know the Eighth Circuit has some propensity in that regard. So what does this really mean? Do we need to deal with it? We already have a judicial stay. We already have an SEC stay, and we might have a judicial stay. Do we need to comply? Do we need to worry about it? And the answer is yes, you should worry about it. You should continue to advance your efforts to put yourself in a position to comply. And there's several reasons for that. First, the rule's fate in court is uncertain. We just don't know how that is going to turn out, not just in the beginning with stays, but on the merits. And it's going to take quite some time, probably years, to have that sort out. The second is that on its face, the rule in its final form is quite different from the draft rule and is much more reasonably possible to survive court challenge. I'm not now making a prediction, but I am saying that the chances are reasonably good that some version of the rule will ultimately come into force. And the third reason is practical. It's going to take most companies a good bit of effort and time to prepare themselves structurally in terms of policy architecture and personnel and the like, and development of protocols in conjunction with their accounting firms to be able to comply with the rule when it does come into effect, if it comes into effect in the future. So it is still worthwhile looking at what it requires. So let's do that. Let's turn first to the accounting requirements. These are the ones that relate to the financial statement and appear under Rule X. The essence here of the requirements is that you have to account for severe weather events and other natural conditions to the extent they have a material impact. And the materiality here is going to be viewed on the basis of a threshold, a numerical one that is established in the rule. And it's a 1% threshold for expenses, 1% of pre-tax income, or 1% of shareholders' equity in the case of capitalized costs and charges. We need to talk a little bit about what severe weather events and other natural conditions actually means. And I'm going to call that SWENK. That's just my acronym. It's a little easier than saying the whole litany of severe weather events and other natural conditions. So SWENK is not defined in the rule, but we nevertheless have a pretty good working understanding of it because of how the SEC has been talking about it and writing about it. We know it's hurricanes, tornadoes, flooding, drought, things that are physical and related to Mother Nature. That is my rough and ready definition. What we don't know, though, is whether the reporting obligation here relates only to those SWENKs, those natural conditions, that are unusual or more frequent or extra severe. So if your operations are already in Tornado Alley in the United States and you regularly deal with tornado risk, is that itself something that may trigger reporting requirements here? Or is it only an increase in severity or frequency or increase in the costs associated with those expected events? The SEC in its rule did not tell us the answer to the question, but they acknowledged the question and acknowledged that it has different answers, but then withheld its answer. Not very helpful. So we don't really know how that's going to be handled. And both the major law firms using this rule, as like Bracewell, and the major accounting firms were in dialogue with one another about how to handle that. The second piece here that we need to really focus on is not just the amount of the damages attributed to the severe weather events, but the contextual information that you have to provide if you trigger over the 1% threshold the duty to account for the impacts. There's a lot of contextual information that's required. And this begins to set a general principle about the rule, which we'll come to several times in this discussion. Namely, there's kind of a two-step process. There's a gating question. Do you have to report? Do you get over the threshold? And then the second question is, if you get over the threshold, what is the scope of the disclosure obligation? What information? And there's usually a fairly narrow threshold of materiality or 1%, something like that, but then a very broad set of contextual information that you then need to provide. And that's true here on the accounting side, where you need to explain, how did you derive, how did you track these costs? How do you identify them and trace them back to the SWENK? What are your assumptions, protocols, policy decisions? All of that needs to be disclosed in relation to reporting and accounting for the severe weather event. Let's turn now away from SX disclosure to SK disclosure and the key disclosure or narrative disclosure requirements. So these aren't necessarily appearing on your financial statement, but they are things that need to be discussed in your narrative discussion, in your 10K, in your 10Qs, and so forth. There are several different topics to touch upon. Governance is probably a good one to start with. You do need to disclose the board's oversight of climate-related risk. And that term, climate-related risk, what I'll call CRR, is the bedrock term within the rule. And we'll talk a little bit more in a few minutes about some complexities about what climate-related risk might really include. Conceptually, it is defined in the rule. It includes transition risk and physical risk. But there are some challenges, especially with the transition risk, when we get to the boundaries of that definition. But for now, on the governance side, take note that there's not a materiality threshold here for governance disclosure on CRR. You do need to disclose how the board deals with or oversees climate-related risk, how management approaches these issues, how you oversee or the company oversees progress toward any targets or goals or transition plans that it has. There's a diving into the process of oversight and management of risk relating to climate. That is now part of the disclosure requirement when the rule becomes effective down the road. Second topic is really the main, almost the main course here in the rule. That's what they call risk management and strategy in the rule. The base obligation is to disclose climate-related risk that has a material effect on the business's strategy, on the business's results of operation, on its general financial condition. So material climate-related risk has to be disclosed. We're going to talk about some of the complexity around, well, how do you gauge materiality when you're talking about climate, and what are the boundaries of that risk? But let's park that for a moment, recognizing that that's that first gating question, and let's turn for a moment to that second question of if you do get past that gating question and you have to disclose, what's the ambit of the disclosure? What do you then need to disclose? And that is very broad here. You have to describe in detail all the actual and potential impacts and the mitigation efforts, what you are doing, how you are doing it, and whether those mitigation efforts are successful. You have to describe how that material CRR is integrated in your business planning or in your business model. Are you shifting away from fossil fuels, for example? What's your strategy? You have to describe any and all of your processes to identify this risk or assess it or evaluate it or manage it. There's a lot of detail here. On the last point on this slide, I want to highlight in particular that in the rule, embedded actually in the regulatory language, not in the preamble, the rule shines a spotlight on a recommendation. Now, usually regulatory language just gives you a requirement. Here, the rule focuses on analyzing whether you should report a material transition risk if your operations are in a jurisdiction, like a state, that has adopted emission-related or climate-related goals. So that's a very interesting and important clue, and it's embedded in the regulatory language itself. So to repeat, the SEC is telling us not absolutely de jure, if you're in a jurisdiction with climate goals, you have to consider transition risk to be material, but it is warning you that it very well might be material and you need to analyze it. So the subtext here is you have to consider it, and you're going to need to document and explain why you view it as material or not material. Let's talk about targets and goals and transition plans. The SEC has made much of the fact that the rule does not require you to set targets or goals for reducing greenhouse gases or otherwise mitigating climate risk, and it does not require you to have a transition plan. But if you do have any of these things and they are material, you need to disclose them and discuss them in detail. So let's talk about what makes a target or a goal material and therefore triggering the disclosure obligation. Well, you might think that a greenhouse gas reduction target would be numerical, and therefore maybe the size of the target, the ambitiousness of the target would be the threshold of materiality. Or maybe it would relate to the impact, the reduced impact to the environment of achieving that goal. Or maybe it ought to be the expense involved in achieving that goal or trying to achieve it. It's none of the above. The materiality that is focused on here in the rule with respect to targets and goals is whether or not the target or goal itself is having a material effect on your business. So it's not impact related to the environment, it's impact to your business. What does that mean? Is it shaping, is the goal or the target shaping how you strategize, how you make business decisions? Is it integrated in your planning? Well, that is demonstrating that the target or goal is embedded in your business and is having potentially a material impact on that business. And so the SEC has very interestingly pinned materiality of targets and goals not to their impact or expense, but to whether and to what extent they're impacting how you run the business. I think that is a relatively low tripwire and probably intentionally so. And if you do trip over that tripwire and you do then have targets and goals that are material because you're planning your business around them to some degree that you deem material or might be material, then you have to provide a lot of information. In fact, any and all additional information that is necessary to fully explain and understand how that target goal setting is working and how you're managing it in the company, how it relates to your business model as a whole, your business strategies, your operations, what your progress is. And you need to update your progress toward the goal on an annual basis. Describe the mitigation, how you're achieving your goal or how you're failing to achieve it, also annually updated. Somewhat similar story with transition plans. The rule doesn't require you to have one, but if you do have one and it relates to a material risk, such as a material transition risk, then you have to disclose it and provide a bunch of information. We're going to come back to what might trigger that transition plan in a moment. Let's talk first, though, about scenario plans and internal carbon prices. Like targets, goals, and transition plans, these are tools. These are tools that the SEC knows companies are increasingly using to understand and examine and explore what climate-related risk might mean for the company. So they have in this rule addressed scenario plans. You don't need to conduct scenario planning, but if you use a scenario plan and you determine on the basis of that plan that there could be a material effect or a material effect is reasonably likely, then you're going to have to disclose a bunch about the scenario planning, how it works, parameters, assumptions, significant policy decisions around it, analytical choices in the model. I want to highlight something that's unusual and very important. I think it's going to be a significant issue just as a practical matter, but also a philosophical one. Scenario planning is not actually future prediction. It's not about trying to divine what the weather is going to be in the future, for example. That's a predictive weather model. Scenario planning does something different. That's why scenario planning often involves multiple scenarios. It doesn't try to predict the future. It actually assumes a future of given parameters at the outset and then asks, in that assumed future, what does the world look like? How does our business environment look? And how does our business strategy fit into that future business environment? And that isn't predictive of the future. It is a diagnostic of how you fit into a potential future. So when we have a threshold for disclosure of scenario plans that cues off of whether a scenario plan resulted in a reasonably likely to be material output, then we're mixing two things. The probabilistic future prediction part of the SEC and this, the 33 and the 34 acts about reasonable likelihood, that's predictive. That is intended to tell us about what we think the future will hold. And that is being applied to something, scenario planning, that's actually not future predictive. It's not intended to be. It is intended to be diagnostic. So we have a mix here of a probabilistic threshold being applied to a non-probabilistic tool. It's inherently intention and may generate or may need some additional thought and policy guidance around it within companies. Internal carbon pricing. Some companies use internal carbon prices to assume a carbon price of X dollars a ton or some other metric like that to factor that into their cost planning for capital deployment, for example. SEC does not require you to have an internal carbon price, but if you do have one and it is material, again, the question, material to what? You mean it's a very high carbon price or a very low carbon price? No, that's not the materiality. The materiality in carbon pricing relates to whether the carbon pricing is material to your evaluation of risk. If, in other words, it's just a sideshow and you barely attend to it as not an important part of your analysis, well, then maybe it's not material and doesn't need to be disclosed. But the question is then begged, why are you doing it if you don't think it's important to your analysis, right? So there is a kind of latent assumption here that if you're doing internal carbon pricing and you're using it because you think it has an effect on your analysis. And that may trigger that materiality threshold, that gating question of whether you need to disclose the internal carbon price. And of course, if you do, then you need to discuss it in full, as we've talked about. So let's turn now to greenhouse gas emission metrics. And you may wonder, gosh, why isn't Ewing talking about scope 1, scope 2? Isn't that the story here of the rule and not scope 3? And the answer is, in my view, to be honest, the actual emission metrics have been kind of relegated to the caboose, the back end of this rule. It is not, in my view, really the central thrust of the rule. I think the other things we've been talking about in disclosure requirements, especially around transition risk, are much more the focal point of the rule and the SEC's intentions in applying it. But they do have metrical requirements. As everyone has read, scope 1 as well as scope 2 need to be considered for their materiality. If scope 1 is material, you need to disclose. If scope 2 is material, you need to disclose. And you do not need to consider scope 3 for its materiality as a disclosure item. That's kind of the once over lightly. If you do have material scope 1 or scope 2, and therefore have to disclose them, you need to supply a bucket of information, methodologies, inputs, assumptions, how you define your organizational and operational boundaries, all the protocols you use, analytical assumptions or choices that you have, and so forth and so on. But let's go back to that question about materiality. How do you know that your scope 1 or your scope 2 emissions, which is a number, an amount, is significant enough to be material for SEC purposes? Well, since it's numerical and it is quantitative and it's measured to a large extent, one would think materiality would have a numerical threshold. But the SEC was shrewd and probably wise in not setting a numerical or volumetric threshold of materiality for anyone. They have shied well away from that, and they probably wouldn't have been defensible under the APA had they done that. So next possibility is, well, what about looking at the materiality of the emissions to the globe's climate? Well, turns out that's not a good way to do it either. At least that's not the way the SEC is thinking about it. And they've gone so far as to say the number itself, the emissions number, the quantum of that number, is not a basis for making your materiality decision. Let's just pause on that for a second. That's pretty interesting. What that is telling us is a number that is actually largely a measured number, which is all about creating relational significance numerically. That's what a numbering system is not to be assessed for its significance based on the number. Think about that for a moment. That's unusual. So how do we approach materiality when it comes to emissions metrics? That is going to be an area of significant continuing discussion and debate. And it's in discussion between the big accounting firms and the major law firms in this area as we all try to grapple with that. How do we assess that materiality? The reality is that the implied materiality of talking about scope 1 and scope 2, just talking about it in voluntary reports and elsewhere, that itself builds a kind of expectation of materiality that I think the SEC is trying to harness here. And I think we're going to find that very few companies feel comfortable saying that they do not need to disclose these numbers. Yes, the numbers need to be attested, and there's a limited and reasonable assurance schedule there. So let's really dive into that material climate-related risk. How do we deal with materiality here? I mean, we saw with scope 1 and scope 2 is which are numerical and yet are not subject to a materiality threshold that's numerical. How do we deal with this? I think we need to focus in on the transition risk part. The physical risk leads to repair damages, costs. It's a little easier to get your arms around that because it's like dollars and cents. And you can compare that to the balance sheet. But when it comes to transition risk, that's future-oriented. So let's look at how we deal with trends and uncertainties in the management's discussion and analysis part of the 10K. That's the MD&A. And we have a long-standing understanding and direction from the SEC about how materiality is to be judged in the context of trends, known trends, and uncertainties. And that is a two-step process. And here it's very important to understand that an MDA, the materiality rubric, flips the burden of proof. It basically says you must disclose unless you can make one of two determinations. So the default is in favor of disclosure around a future trend or uncertainty like transition risk. And the first possible determination to get you out of that obligation is that you determine and can back up and prove, right, in court as necessary, that the risk that you associate with a carbon-constrained world is unlikely ever to happen. We're not going to have a carbon-constrained world, for example. Or if you can't make that determination, you can say, even if we do have a carbon-constrained world and there's risk associated with transitioning toward it, the impact of that on our company is not going to be significant or material. So one relates to whether it occurs, and the other relates to whether it's reasonably likely to have a material impact. The problem here, as a practical matter, is with transition risk, we're talking about a multi-decadal period, 20, 30 more years, in which we're looking at an uncertainty that is in part a policy uncertainty. The carbon constraints are policy driven by states and countries and international regimes. So it's very difficult for companies to document that there will not be even a reasonable likelihood that there will be a transition risk associated with a carbon constraint, or that we know even now that over the next several decades, there will not be any material or reasonable likelihood of a material impact. So that's where we're going to have to wrestle. We're going to have to wrestle with the MD&A rubric for gauging materiality in relation to transition risk. I think the scope 1 and 2 metrics are going to be less significant to focus on. So let's also touch briefly on voluntary sustainability reporting. There are risks in overlapping reporting in two different regimes, both mandatory in your 10K and elsewhere in a voluntary report. But frankly, how prudent is it going to be to just stop your voluntary reporting? It's not prudent, most likely for most companies. And that's because the reputational effect in the marketplace of suddenly retreating from the disclosures that you've been engaging shareholders and stakeholders with is likely to imply a disinvestment, maybe even a disbelief in climate as a relevant topic, a retrenchment in positions on climate. That is unlikely to be helpful to the reputation of a company in the marketplace. So this is much more about figuring out how to find coexistence with voluntary reporting and mandatory reporting if and when the rule becomes effective. And we recommend here at least thinking hard about creating much better integration in the teams, literally the people, the personnel, and the procedures and protocols that are used for or that are involved in rolling up the 10K disclosures and the financial disclosures on the one hand, and working on the SEC disclosure. And also think about setting tripwires before you make additional commitments. The ESG side of the house may be all game to make a new carbon reduction commitment because you've been working toward it for a few years. But now, in the context of this rule, we need to think hard about the legal and financial consequences of that if the rule were to go into effect. Are there compliance challenges here? Yes, you see them, we see them. There are accounting challenges in how you trace impacts back to naturally occurring events in Mother Nature, how you assess materiality in a qualitative way and not quantitative, the risks of divergent disclosure of the same topics in different places, stumbling into obligations by adopting carbon targets before you're really ready for the consequences of disclosing about it. All of these will result in compliance challenges. And of course, legal risks that are associated with that follow. We will expect inquiries from staff, letter campaigns, SEC enforcement, shareholder proxy proposals, possibly even shareholder actions. All of these have been there from the beginning. The SEC rule only galvanizes them and provides them an additional context and anchor point in making their arguments, but it is not itself the progenitor of these legal risks. The potential risk mitigation, we've covered these as we've gone along. I encourage you to look at this slide as you go back over your notes or think about these issues. But being systematic is probably the most important piece. Working systematically to integrate legal, financial, and environmental reporting concepts designing protocols in consultation with the big accounting firms and your law firms is very important, especially around materiality and the documentation needed to demonstrate why you're drawing materiality conclusions the way you are. A final word on the bottom: fuzzy requirements like fuzzy boundaries to materiality call for and put a premium on documentation and consistency in the application of policy. You may be wrong in an assessment, but if you're consistently wrong because you applied a consistent principle, you at least have a secondary level of defensibility. I hope this has been helpful as an introduction. There's lots here. Glad to entertain questions down the road as any of you start grappling with these issues. Thank you.